All about deemed exports. What is deemed exports? Deemed exports for the purpose of this FTP refer to those transactions in which goods supplied do not leave country, and payment for such supplies is received either in Indian rupees or in free foreign exchange. Supply of goods as specified in below shall be regarded as deemed exports provided goods are manufactured in India. Categories of supply. Supply of goods under following categories: A to D, by a manufacturer, and under categories E to H, by main subcontractors shall be regarded as deemed exports. A. Supply by manufacturer. A. Supply of goods against advance authorization. Advance authorization for annual requirement, FA. B. Supply of goods to /STP/EHTP/BTP. C. Supply of capital goods against TPCG authorization. D. Deleted. B. Supply by main subcontractor, S. E. I. Supply of goods to projects financed by multilateral or bilateral agencies, funds as notified by Department of Economic Affairs, DEA, MOF, where legal agreements provide for tender evaluation without including customs duty. 2. Supply and installation of goods and equipment, single responsibility of turnkey contracts, to projects financed by multilateral or bilateral agencies, funds as notified by Department of Economic Affairs, DEA, MOF, for which bids have been invited and evaluated on the basis of delivered duty paid, DDP, prices for goods manufactured abroad. 3. Supplies covered in this paragraph shall be under International Competitive Bidding, ICB, in accordance with procedures of those agencies, funds. 4. A list of agencies covered under this paragraph for deemed export benefits is given in Appendix 7A. F. A supply of goods to any project or for any purpose in respect of which the Ministry of Finance, by erstwhile Notification Number 12/2012 Customs dated March 17, 2012, as amended from time to time, had permitted import of such goods at zero customs duty, with exemption of both BCD and CVD, subject to conditions specified therein and which are continued under the Customs Notification Number 50/2017 Customs dated June 30, 2017 with exemption of zero basic customs duty and subject to conditions mentioned in the said new notification. Benefits of deemed exports shall be available only if the supply is made under procedure of ICB. 2. Supply of goods required for setting up of any mega power project, as specified in the List 31 at SL. Number 598 of Department of Revenue Notification Number 50/2017 Customs dated June 30, 2017, as amended from time to time and subject to conditions mentioned therein, shall be eligible for deemed export benefits provided such mega power project conforms to the threshold generation capacity specified in the above said notification. 3. For mega power projects, ICB condition would not be mandatory if the requisite quantum of power has been tied up through tariff-based competitive bidding or if the project had been awarded through tariff-based competitive bidding. G. Supply of goods to United Nations or international organization for their official use or supplied to the projects financed by the said United Nations or an international organization approved by Government of India in pursuance of Section 3 of United Nations Privileges and Immunities Act, 1947. List of such organization and conditions applicable to such supplies is given in the Customs Notification Number 8497 Customs dated November 11, 1997, as amended from time to time. A list of agencies covered under this paragraph is given in Appendix 7B. H. Supply of goods to nuclear power projects provided. I. Such goods are required for setting up of any nuclear power project as specified in the List 32 at SL. Number 602, Customs Notification Number 50/2017 Customs dated June 30, 2017, as amended from time to time and subject to conditions mentioned therein. 2. The project should have a capacity of 440 megawatts or more. 3. A certificate to the effect is required to be issued by an officer not below the rank of Joint Secretary to Government of India, in Department of Atomic Energy. 4. Tender is invited through National Competitive Bidding, NCB, or through ICB. Benefits for deemed exports. Deemed exports shall be eligible for any, all of following benefits in respect of manufacture and supply of goods, qualifying as deemed exports, subject to terms and conditions as given in HBP and ANF 7A. A. Advance authorization. Advance authorization for annual requirement, FA. B. Deemed export drawback for BCD. C. Refund of terminal excise duty for excisable goods mentioned in Schedule 4 of Central Excise Act 1944 provided the supply is eligible under that category of deemed exports and there is no exemption. Conditions for refund of terminal excise duty. I. Supply of goods will be eligible for refund of terminal excise duty as per para 7.03, c, of FTP. Provided recipient of goods does not avail said credit, rebate on such goods. Conditions for refund of deemed export drawback. Supplies will be eligible for deemed export drawback as per para 7.03, b, of FTP, as under. The refund of drawback in the form of basic customs duty of the inputs used in manufacture and supply under the said category shall be given on brand rate basis upon submission of documents evidencing actual payment of basic custom duties. What is deemed export under GST? Deemed exports mean those supplies which are not exports in effect but deemed to be exported. The concept of deemed exports is not new as the same was in place in erstwhile Central Excise as well as VAT regime. Deemed exports ensure that the supply of goods which are ultimately exported do not suffer much tax. Sec 147 of the CGST Act, 2017, Act, provides that the government may, on the recommendations of the Council, notify certain supplies of goods as deemed exports, where goods supply do not leave India, and payment for such supplies is received either in Indian rupees or in convertible foreign exchange, if such goods are manufactured in India. Notification number 48/Central Tax dated October 18, 2017 notifies a list of supply of goods to be treated as deemed exports which is as under. 1. Supply of goods by a registered person against advance authorization, that is supplies made to AA holder. Advance authorization means an authorization issued by the Director General of Foreign Trade under Chapter 4 of the Foreign Trade Policy 2015-20 for import or domestic procurement of inputs on pre-import basis for physical exports. It is worthwhile to note that condition of pre-import was removed via notification number 01/2019 Customs dated October 1, 2019. The same was also struck down by Honorable Gujarat HC in the case of Yasho Industries Limited and others as in violation of Article 14 to the Constitution of India being arbitrary and unreasonable. Pre-import means imports should precede exports, that is there should be 1-to-1 correlation between the imports made under 1AA and exports arising out of imported material under that AA should only use for making exports to fulfill export obligation under that AA. For instance, PH Limited imported silicon cream base, the raw material used in manufacturing a cosmetic product. The import was made under AA number 001 of 1 kg with an export obligation of 120% of value of imports. PH Limited is importing the raw material regularly in different lot sizes. Pre-import condition will require to show a correlation of 1 kg imported under AA number 001 to the exports made using that 1 kg. It cannot be practically possible to such correlation because the company may use its previous stock of raw materials to make exports first because of many commercial reasons which makes impossible to satisfy pre-import condition. 2. Supply of capital goods by a registered person against export promotion capital goods authorization, that is supply of goods to an EPCG holder. 3. Supply of goods by a registered person to export-oriented unit, EOU. means an export-oriented unit or electronic hardware technology park unit or software technology park unit or biotechnology park unit approved in accordance with the provisions of Chapter 6 of the Foreign Trade Policy 2015-20. 4. Supply of gold by a bank or public sector undertaking specified in the Notification Number 52/2017 Customs dated June 30, 2017 against advance authorization. Goods to be supplied as per point 1 to 4 must be manufactured in India. Deemed exports is only for goods and not for services. Deemed exports by units. As per Sec. 7(5) of the Integrated Tax Act, 2017, supply of goods or services to or by a special economic zone developer or a special economic zone unit shall be treated as interstate supply. Supply of goods by units to the recipient referred to in point 1 to 4 shall also be treated as deemed exports. There are 2 levies of IGST on supplies made by viz. I. Unit liable to pay IGST US 7(5) of the IGST Act 2. Levy of IGST US 3 of the Customs Tariff Act, 1975 for imports made from units by the customer. As per Customs Notification Number 79/2017 and 35/2018, the procurements made by the AA holder is exempt from the levy of IGST, if applicable, up to September 30, 2018 extended up till March 31, 2019 via Notification Number 66/2018 and even further extended up till March 31, 2020. Procurement made from is considered as imports in the hands of AA and AA unit liable to pay IGST US 3 of the Customs Tariff Act. However, the same exempt under the above notifications up till March 31, 2020. Further, unit supplying goods to AA holder is not liable to pay IGST under forward charge as any supply of goods made by is treated as import in the hands of buyer as per the Act, 2005 which override any other law. Therefore, the provisions of Sec. 7(5) do not attract at all. Since exemption is available to AA holder the transaction. Difference between deemed exports and zero-rated supplies. As per Sec. 16 of the IGST Act, only export of goods, services out of India and supplies made to units or developer are treated as zero-rated supplies, whereas deemed exports means supplies made to specified categories of persons as notified US 147. Zero-rated supplies may be a supply of goods or services, whereas deemed exports will always be a supply of goods as language of Sec. 147 is very clear that only supplies of goods to specified persons can be notified as deemed exports. Deemed exports is chargeable to tax whereas zero-rated supplies if made under bond or lot will not be chargeable to tax. Zero-rated supplies if chargeable to tax, when not made under bond, lot, shall always be subject to IGST as per Sec. 7(5) of the IGST Act. Whereas deemed exports may be subject to IGST or CGST and SGST depending upon the place of supply. The taxpayer making zero-rated supplies may claim refund of IGST paid on same or refund of unutilized ITC used in making zero-rated supplies. Whereas in case of deemed exports, either the supplier or recipient can claim refund of tax paid on deemed exports transaction. Supplier is not required to realize the sales proceeds for claiming refund benefits under zero-rated supplies. Supplier is mandatorily required to realize the sales proceeds either in INR or Forex before applying for any refund benefits of deemed exports. Deemed exporter supplier is required to intimate to the jurisdictional GST officer and make further correspondence relating to transaction. No such prior intimations/correspondences are required in case of zero-rated supplies. Zero-rated supplies can be made of imported goods too, whereas trading of imported goods cannot be treated as deemed exports. In fact, for deemed exports goods must be manufactured in India. Contact for claiming deemed exports benefits under FTP, Simon Exim Private Limited, E96, Ground floor, Lajpat Nagar, Part 1, New Delhi 110,024 www.consultancy.com